And welcome to Justice Served TV. Michael Bryant here, Linda Kenney Baden there. Hey, how's it going? You good? You good?
I'm good.
Stay right where you are, folks. We have coming up someone who is inside the Karen Reed Court today. Although I'm not even sure I can call it the Karen Reed Court, but it was in. We know it was in Dedham, right? And we also will have a little something for you later tonight called Mad Libs.
Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome back once again. So we have a special guest. We should get right to it. There was a hearing today in Dedham. You'll know the video when we get to it a little bit later on. But before we do that, we thought we'd bring in somebody who was there. Was it the Karen Reed case? Was it the Aidan Kearney case? I don't know. Ted Daniel is here to help us. Ted, how are you? Good to see you.
Guys, how are you? Thank you for having me on. I'm trying to get. Sorry. I just got off of work, and I'm trying to get this set up as quickly as possible. The lighting is about as horrible as it can possibly be.
I thought you were in a hostage video.
Yeah, we're just going to have to roll with it. I'll come closer to the light.
That's fine. We're good. We're good.
We appreciate the effort. We do. We know you're scrambling there. So give us the kind of paint the picture for us. What was today all about?
Yeah, so I originally was under the impression that it was a Karen Reed hearing, but it was actually an Aidan Kearney hearing because it's all under the umbrella. Usually it's under the umbrella of an indictment. This one was under the umbrella of a search warrant. So the search warrant names Aidan Kearney Turtle Boy. And so it was under the umbrella of that search warrant, not necessarily his other witness intimidation cases, but an ongoing investigation. So this is the battle that's been going on. You know, you figured once Karen Reed was acquitted in the murder of John O'Keefe, her legal troubles, at least on the criminal side, would be over. But, you know, we learned, a couple months after she was acquitted that they're holding on to her phones and they have an open investigation looking at witness intimidation. The wild part about it is, as I'm sure you guys have talked about before, they brought this to a grand jury previously. Mm-hmm. And
no bill.
No bill, which you guys know better than I do. I mean, it never happens.
No, grand jury can indict not even a ham sandwich.
They could not find the ham sandwich.
A crumb of bread. I mean, and as a matter of fact, they didn't. Wasn't there a federal case recently where somebody threw a ham sandwich at a federal officer and they didn't indict that? So maybe the rules don't apply, but this looks a little bit. Did it sound a little bit like this? There's the same players involved in here. Did it sound to you like there may be a little bit of like retribution? A little, we're going to go after you because we're not going to lose.
Well, I mean, this is a special prosecutor hired by the district attorney, Michael Morrissey, and this guy's a former judge. He's been around the block. I don't think he follows social media like most of the people who are invested in this case and this, whole saga involving Aidan Kearney and Karen Reed, like where we're following every move. I don't think he follows any of it. So I don't think he's concerned about any backlash. He's getting a paycheck. Remember, you're a special prosecutor, so you're billing hours. So what's to stop him or to keep him from taking this as far as he's allowed to go?
Yeah, and he may not be getting a check much longer. If he gets excised, not just from the one case that he asked to be released from, which I believe was the 2023 case. Correct me if I'm wrong. But there's movement afoot to get him off all of these cases. So Cosgrove may not have that check all that much longer.
Yeah, that's what Tim Bradel. So this was Aidan Kearney was on the stream in the hearing by video. His attorney Tim Bradel was in the courtroom, and he talked about that afterwards. That would like to get Robert Cosgrove off all the cases involving Aidan Kearney. But I don't know if the judges would be inclined to do that. I actually felt that the judge was leaning more towards setting parameters for the search of Karen Reed's phone than he was for just saying, no, give the phones back. That was the impression that I was left with.
Does it ever end in Massachusetts? Is there? I mean, you know, I've appeared most times in federal court. Tried a lot of cases in federal court. The federal judge is like, there's an end. I mean, I don't care which political party you're from. You do things. You do it now. You don't do it now. Goodbye. So long. Farewell. This seems to be like it just goes on and on and on.
Yeah. And if it was January 2024, I remember that they seized her phones. And when the search warrant return came out, you know, like 5 or 10 days later, that's the whole, you know, it's probably 50 pages. And that's where they allege that Karen Reed colluded with Aidan Kearney because they already had Aidan Kearney, Turtle Boy's phone. So that's where they were getting that information from. And one of the things that I think Karen Reed's lawyer said is, you already have the other side of this. Why do you need her phone? You already have, you know, if you look what was papered in the search warrant, they have all the stuff that they believe happened. So what is the purpose of getting her end of it if you have all the information that you brought to a grand jury already?
Do you think they smell?
Let me ask Linda, how'd the court respond to that argument? Yeah, were they receptive to that argument?
I don't think it didn't seem to me. It didn't seem to me that Judge Krupp was really focusing. He just sort of said to Karen's attorney, Steve Buzang, so what's the case law on this in terms of, because Steve's argument is, you know, you've had the phone for more than 500 days. And the judge wanted to know, like, okay, what's the case law that says you can only hold it for a specific amount of time? And I don't think there was immediate case law that he was able to bring to the table. And those were the type of things that I don't know if Judge Krupp was looking at this holistically. It seemed more like, you know, what judges are supposed to do. What is the case law? How do we apply it here?
And my question is, do you think because of the civil suits that she intends to bring and the fact that they returned the car allegedly smelling of pee-pee, whether it be rat pee or personal pee, that they think they can trade off what's ever in those phones for a civil suit settlement? Any indication of that?
I know, but that was interesting. That when I was first told that they were holding on to the phones, the theory that was given to me by someone deep inside Karen Reed's circle was, oh, they're holding on to the phones because they want to find a way to get them into the civil case. They want to find a way to make sure those phones are preserved for the civil case. But that wasn't it at all. It was because, you know, Robert Cosgrove, the special prosecutor, says he's not done.
And he's acting, you know, at the pleasure of Michael Morrissey. So I'm just going to assume that there's some puppet strings being pulled, and he's just doing what he's been told to do. Do you get the impression that he's acting on his own?
I actually don't know that. I think that due to what's come out about Morrissey's communications, you know, with judges, and I would be hard pressed to think that he would continue, you know, sort of advocacy one way or the other, because sort of in the Aidan Kearney case, I think Kearney kind of exposed that he was using his own personal email to make these ex parte communications. And so I don't know. I don't know. The DA's office certainly denies it. I can't even get a comment from them when I say, hey, what's the deal? They said, well, he doesn't work for us, so we can't speak for him. That's their official line.
You know, Ted, I think I mentioned to you off camera that I had a very good experience in Suffolk County with our judge when we tried the double homicide case for Aaron Hernandez, double murder case, after he'd already been convicted of the murder in Fall River. Our judge gave us a very fair trial. We went at him a number of times. He would either back down or we'd have a discussion at sidebar, which, by the way, everybody, that's where cases really get tried, at sidebar, in case you don't know. All right. And had no problems with him. We liked him. We respected him. And after the trial ended, his whole team sent us emails how they respected us, so they were the best team that they'd ever seen. So I didn't have any of this kind of stuff that seems to be going on. Is it endemic to? Is it like the ghost of Sacco and Vanzetti, that just won't leave Norfolk County, or you're there, or you may be there for like ever covering this case. What do you think?
Yeah, I mean, I certainly think that Karen Reed was probably the most aggressive defendant to ever be tried in Norfolk County, and they're not used to that. I don't think they were used to the likes of Alan Jackson, the way he, argued in the court, and the way he was more than willing to challenge people. So I do think that Massachusetts is kind of parochial, and it's, who knows who, and there's it's so cloistered here. We always get the award for like the state that's hardest to get records from, and it's just kind of like an old system that I think Karen Reed sort of rocked to the core, and but these folks don't want to necessarily I think they've had to concede that she was found not guilty in her trial, but they don't want to concede anywhere they don't have to.
Yeah.
It's crazy. Hey, Ted, we appreciate the time you spent. Let me ask you one more thing before we let you go.
Yeah.
They seem to have pushed off any real resolution on this phone issue to December 5th. Did I read that right, or is something going to be happening between now and then?
Yeah, so and that's one thing I think even the lawyers were trying to fully understand. The judge said he would take the issue under advisement, but he does want the counselors from both sides to get together and talk about, if there were to be an extraction, how that would work. So I don't know for sure when we'll get a decision on this, and I wish I did, and I think the lawyers were a little perplexed too by what happened.
Yep. Not surprising. Well, great work on this case and others,
Thank
Ted.
you.
We appreciate you popping in to give us the update. Take
Thanks
care,
for
sir.
having me. I'll get a better shot next time.
Oh, you're right. It's what you say that counts.
Take care, man.
All right. Take care.
Bye. That's nice to have a little update there from the king of this story. So what I thought we would do is,
let me just give him a plug. He is such a great reporter. I mean, and he
like
he
good old fashioned reporting,
like really good old fashioned reporting. Isn't it nice? Isn't it wonderful? Isn't it terrific? And you can follow him at the Ted Daniel News, I think is his handle.
Yeah, he is with want to make sure. Yeah, he's
thank you for his channel for letting him come on, Justice Serve TV. We greatly appreciate it, and that's why we try to do the news. As we say, we try to do no drama rama, although we're going to play a little bit of a game later on, but no drama rama when we're giving to you. We're not high school kids.
I know.
We're not doing that.
Nuh-uh. She did. Mom, she did that. She had it first. So the guts of this hearing is only like 20 some minutes. So we're going to play that and chime in as we feel appropriate for those who may have missed it from earlier today. And then we have related to another Aidan Kearney issue. And I forgot to mention, I checked in with the Aidan Kearney supplemental Betero motion that we're doing the Mad Libs. But I checked with Aidan before this hearing. I said, what's that? And he's like, that's not us. We're not even going. And then he was there, officially on Zoom, just because, you don't have one of those Bradel moments where the court says, where are you? Get down here.
Know what? I'm sure he doesn't trust anything that's happening there.
I would not either.
But tomorrow, when we have the show to discuss New Jersey and the cyber stalking, we have the best experts lined up. I'm from New Jersey. I practice criminal law in New Jersey. All right. We've already got the legislative history. We've already got the case law. We've already got everything. And we've got the attorneys who practice in New Jersey. And if you think that you're going to bring that any kind of Massachusetts, like Sacco and Vanzetti, good old boy network to New Jersey, you got another thing coming, because boy, baby, it's the Alan Jacksons in every courtroom down there.
And this is related to what could be another case against Aidan Kearney that's venued in New Jersey. That's for tomorrow. It's hard to keep up with all of his stuff. So anyway, there's Mr. Bradel, and so let's just listen in on some of this, and then we'll chat as it unfolds.
Whose things matter? I'm not sure that it's necessarily, I guess it's denominated 24SW0004, but it really is a request.
That's SW, the number he just gave, as in search warrant. So it's bizarre on its face that it's related to a search warrant for a case that's really done.
For setting a set of conditions for searching through Ms. Reed's phone under a protocol that would assure against the sharing of privileged information. It seemed to me that the Commonwealth's request and Ms. Reed's response spoke completely past each other and didn't address the merits of each other's papers, which is why I felt like I needed a hearing. As far as I can tell, the phone has already been downloaded, searched in terms of what the court authorized previously, and it just hasn't been looked at yet, and it has to be looked at subject to a particular protocol. Do I have that right, Mr. Cosgrove?
I don't know if it has actually been downloaded, Your Honor.
If it hasn't been downloaded, that's a set of facts very different from what I understood to be the case. Because I think I authorized the download, and I thought that there was a representation in the papers that it had been within a days of the authorization. Let me just see if I can find it in the papers.
You may have, well, okay.
First of all, Cosgrove should know one way or the other. He should know.
1001, 1002, 1003, 1004.
I think the representation is that the phones were seized pursuant to authorization. I don't think, and I don't purport to be much of an expert on the technical side, that the download can take place absent access to the phone through a password, which would have to take place relevant to the search protocol. If the cell phones have not been downloaded pursuant to a prior order, that raises all the various things that Mr. Buzang presented in his opposition, which is the Commonwealth having been in possession of the phone for an extended period of time has a finite amount of time in which it can seek authorization to search or to do the search. Let me just see for a second.
Michael, can I just stop you and ask you a question?
Sure. While he's paper shuffling. Yeah.
Yeah. Why is it that this Judge Krupp scheduled this? Well, maybe this is why it gets moved later on to the 5th of December to hear this motion, which he could have, get together and as Ted Daniels said, get a protocol together. When there's a whole motion pending that he's conflicted out, and he should not be involved with any ongoing investigation. Is there? Am I missing something here? Or
it just seems like it's all part of the bigger mess. He started the issue, and now it sounds like he's trying to step in, and because he's the guy who signed the warrant, and now he's trying to step in after the Karen Reed acquittal on all but one charge. And clean up that mess, but he's not doing anybody any service here. He's making it more convoluted. Why would you have to take this under advisement, which we know he does? Ted told us about that. We'll see that unfold here, and that's what they always do in Massachusetts. I've never seen anybody with the balls to rule from the bench on anything of substance.
Right.
So, to your question, I don't know why he's stuck his toe in this in the first place, and I don't know why he's diving in the deep end now, considering the end of the Karen Reed case and this is just like a dangling nuisance, right?
Yeah.
The practical fact is, as Ted mentioned, they've had Aidan Kearney's phones forever. If you're looking for conspiracy between Aidan Kearney and Karen Reed, you're going to find the same information on their phones. Otherwise, how is that a conspiracy? So it's already there. It's what bothers me is the waste is incredible. The waste.
The waste is incredible. How much is hey chatters, how much is Cosgrove being paid? How much has he been paid? How much is he being paid? But also it reminds me of when the day after Karen was acquitted, she and Alan Jackson were going out for breakfast near the river there somewhere, and some reporter asked her. She said, "Well, I don't trust anything Morrissey's going to do. I don't trust him." All right, and I think this goes to part of it. You're in their crosshairs for some reason. And unlike Sacco and Vanzetti, they can't kill you and give you the death penalty and shut you up. So maybe they feel they're at a disadvantage.
That's as good of explanation as any, right? Yeah, we're as perplexed as the judge looks right now.
But he's holding the hearing.
So in your motion,
yeah, exactly. And that's why, when I reached out to Aidan, he's like, this is not even us. No.
It says on January 22, 2024, the Commonwealth sought a warrant for mobile devices capable of communicating in cell phones used by Karen Reed. After review, Krupp authorized the warrant. I am paraphrasing. Next paragraph. The search was executed on January 24, 2025 at 14:45 hours by Lieutenant John Fanning, who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with green case and 1 white with clear case. Is that seizure only of the phones, or is it the download of the information contained in the phones? Let me just see. I thought.
Regardless of what the warrant says or reads, and if it's ambiguous about were they just getting the phones, the possession of them, or were they also down, Cosgrove should know this.
Right.
He should know, yes, we got them and we downloaded them.
Wayne said he gets paid $400 an hour. I mean, that's a good reason for a hum.
Yeah. Everything to him is just no rush. There's just no rush.
That there was something in here that said that there was a download, but maybe I mistook that.
If there's something in there that I picked up from...
I'm sorry, you think what?
I think it was just for seizure.
Yeah, I think it was too, but it doesn't matter. The prosecutor should know.
Right.
And he's there saying, I don't know.
$400 an hour, he should know, right.
An affidavit or a previous filing, I don't know, but my understanding is that the phones were seized.
Phones were seized and they haven't been searched.
No,
they haven't been.
And they can't be searched absent access to the phones, which require either the Commonwealth proceeding with breaking the, attempting to break the log-on information, or the receipt of the passcodes.
Okay. Well, so you've been in possession of the phones since January of 2024, and are only now requesting leave to download the information and search the phones.
No, I think we already have leave to download the information pursuant to the warrant. What we have is the practical impossibility of downloading the information. What we're seeking is leave to do the search pursuant to a search protocol.
So he's saying, no, because these are iPhones, remember? And they're tougher to crack. Right. So he wants the passcodes, fine. So what the court should be asking you is, okay, you had the phones and you had the right to search them for those 14 months, whatever it may be, 15 months, but you never asked for the passwords till now. There's still delay in doing your job.
Yeah. It's all of a sudden now we need the passwords for these phones. In the case we already presented to grand jury, and we had to give the car, but we got these phones, and maybe there's something in it. This quite frankly is outrageous.
Well, it
this
is the classic
outrageous.
fishing expedition. There's no doubt about it.
Yeah, yeah.
And you know, you need a judge that'll put his foot down. Do we have one there?
No,
no.
that's what I
We do
said
not.
earlier when I was doing the pre-interview. You know, in federal court, judges will put their foot down. In New Jersey, you're going to find judges will put their foot down. Maybe the first time they'll let you go a little bit, maybe the second time, but they're not going to waste their time. They've got a gazillion other cases sitting out there, and you know, they're not going to waste their time. And by the way, with regard to passwords, that's why people always tell you to put passwords. Lawyers, if you see them, will always say, put passwords on your iPhone, because they can't, if I look at my iPhone and I have it on, like, you know, you can look at me and open it, right? They can force you to do that. They can't force you to give them the password. Okay.
Tricky.
Especially 6. Now, do they get to do? Can they? Has there been situations that the FBI has been able to jailbreak them recently? Yeah, initially they couldn't when you had 6, 7, you know, 6 number passwords. But now there's been some cases where they have jailbroken the phones.
As I understand it, Your Honor, there are two aspects to this. One is the physical seizure of the phone, for which the SJC has imposed prompt requirements to get a warrant after the phones are seized, or in this case, there was a search warrant issued prior to the seizure of the phones. And the second aspect is the second search warrant to search the information. I don't think there's any basis for parceling out downloading as kind of a middle step here with a separate requirement.
Well, what do you say to Ms. Reed's argument, Mr. Buzang, that there's a certain amount of time you have to download if you have the phones, and now more than a year has passed, and it's only now being requested?
Because I always need more time.
Well, there's no question that more than a year has passed, and it's only now being requested. And if Ms. Reed is right, I think that would be dispositive.
So, I mean, he's acknowledging her concern, but he's basically saying we need to get out of jail free card, Judge, to get us past that.
Yeah, you know, the interesting, poor Mr. Buzang just stands up there. He really hasn't had a chance to really say it's his motion. And, you know, as again, this is the difference between New Jersey practice and Massachusetts practice. This is we saw it in Hernandez's case. We get up there and we're yelling and we're talking. Now, the problem you have, and I'm going to tell you a problem. It's a little secret of practicing criminal law. You see the attorneys here. Their practices are here. Their practices are in Massachusetts. Their practices are going before these judges in other clients' cases. They can't afford, like us, who come in pro hoc vice to a case out of state, because all they can do is pull our pro hoc vice, okay? But when all your cases are in front of these judges and you have to be with in front of them pretty much every day, you can't be like, you know, you suck. I need a ruling.
That's a theory, but that explains why I'm not a favored son of any of the cases I take to trial, because I don't give a shit about the judge. I'm not there representing the judge. I'm not there to kiss the judge's ass. I'm there to get the best result for my client. And I don't care if the judge doesn't like me and the next time I show up, he tries to take it out on me, because he can't change the facts, can't change my arguments.
Right. You're right.
Yeah, I just won't do it. And I'm sorry if these guys are actually kowtowing, as they say, because it's wrong.
But I don't think there's any basis in the case law for concluding that Ms. Reed is right. The case law suggests that a warrant.
I'm sorry. I just went berserk on that. I don't think there's any reason in the case law. This judge is going to demand case law because you have a case where you've had a phone that you have seized for 500 some days. You haven't done your job. You have no reason. You've been to grand jury. She's been acquitted. There's no case law like this, except that you are a idiot.
Because, these kinds of situations, common sense tells you they should not exist. So thank God they've not. Remember, law only arrives as a result of an appeal, right? So luckily, if you can't find any case law, nobody's been so stupid as to let this happen before.
A search of cell phones, if that takes place, the Commonwealth must promptly seek a warrant, and the burden of justifying any delay is on the Commonwealth, whether or not the defendant presses for the return of the phone. That rule is designed to protect the defendant's possessory interest in the phone. And that, as I understand it, is based, among other things, on Segura versus the United States, 468 U.S. 796. Now, this case is not a warrantless seizure. It's a seizure pursuant to a lawfully issued search warrant. There are instances of items that have been seized in evidence that may have been subjected to tests years after the fact, sometimes as a result of new evidence or developments in a case. But where a warrant is obtained, the usual and accepted procedure,
Stop.
which so
Hold it.
I'm going crazy here. All right. That's talking about like DNA. So you have seized the clothes of somebody you think is a suspect, and a new test comes along, and you want to do it because you've got those clothes. They've been seized. They haven't been returned because the case is not finished. You haven't charged anyone. They haven't been acquitted. Blah blah blah. And then you want to do new tests that may bring you closer. That's not the case. All right. I'm a little incensed.
All right.
I've seen no evidence that the SJC has changed. Is that the Commonwealth retains the seized items until the conclusion of the case, which time the defendant may move for their return or the Commonwealth may move for other disposition. That's generally General Laws, Chapter 276, Sections 3 through 8. Now, I've looked at the cases that Mr. Buzang has cited.
And Diaz relates to a warrantless seizure of the cell phones and a delay in seeking a warrant to search?
Yes.
Okay. And
Yes.
here we have a warrant that authorized the initial search of the cell phones. Let me ask Mr. Buzang why that isn't dispositive. Is there a case that talks about a circumstance where there is a warrant that is issued to authorize the seizure of the cell phones, which is then where the ultimate search, the contents of the cell phones is delayed and therefore somehow prejudicial to the defendant and is suppressed?
I think, Judge, in this case here, the phones were seized January of 22nd, 2024.
Right, pursuant to my warrant.
To your warrant, exactly, right. Judge. And nothing's been done. The only reason something...
I understand, but do you have a case that says that when that's the circumstance and a year plus passes, they can't come back to the court to seek authorization to go into the phones when the court has originally authorized the seizure of the phones in the first place?
Well, I think Diaz, Judge.
Well, Diaz didn't involve a warrant, apparently, for the seizure of the phone. It was a warrantless seizure of the phone. No judge had viewed the contents of that phone as potentially, or had ruled that the contents of that phone were potentially evidence in a case, right? That there was probable cause or a basis to issue the warrant.
Here's the thing, though, Michael.
So the question is whether you have a case.
There's going to be no case on this, okay? The judge knows this, okay? There's no case on this because she has been acquitted of the charge for which supposedly there'd be an intimidation of witnesses. So, in my opinion, there should be no way you could go after her for, quote, an intimidation of witnesses when she has been acquitted of the charge, and no one has said that she was acquitted of the charge because it was intimidation. The jury said she was acquitted of the charge because no collision, no collision, no collision, and you didn't prove your case. So
yeah,
that's the distinction.
That's all well and good, but he's micro-focusing on something that's basically irrelevant, and it doesn't even matter. It doesn't matter. I think the judge is trying to cover his own ass, because if they find some sort of case law that helps him come to a decision, then it helps him do his job. He just needs to do his job.
He said results that arises in the context of a warrant authorizing the initial seizure of the phones, and then there's a delay in looking at the content of the phones or any other piece of evidence. Warrant authorizes the seizure of hiking boots, and there's a 1.5 year delay on doing DNA testing to see if the boots trudge through mud or blood or whatever the relevant substance is.
You've acquitted the person, and
Sure,
the person
Judge.
right now.
Well, I feel that the reasonableness in delays in obtaining a search.
Remember, he's just talking about the search warrant. We're not relitigating Karen Reed's case.
But
This
that's
is
the
just about
problem.
the search warrant.
That's the problem. The search warrant becomes irrelevant because she can't be tried again on the murder case for which they got the cell phone to see whether she was intimidating witnesses. So she can't be tried again on that. So the intimidation is irrelevant. It had nothing. Because so what?
Well,
So
you're
so
saying
what?
that if they had the goods, they could bring a separate intimidation charge. If they had the
For
goods,
what? For what?
They-
Intimidation for what? That's my point.
well, for the same thing that, well, I'm not saying it happened.
Mhm.
Same thing that Aidan's been charged with.
And Aidan should go down the tubes too. His case.
That's
She's
I'm not
she's in a-
litigating that either. I'm saying they
she's in
could
a
bring a
better-
charge for it. That's what
She's
they're
in
looking
a better
for.
position because they were looking for position intimidating witnesses so she doesn't get convicted or they don't testify. There's been no allegation that a witness didn't testify or didn't get convicted here. So therefore, anything they're going to get out of there is irrelevant for her because it can't be a crime anymore because she's been acquitted and they can't bring the charge against her. That's my argument.
I would disagree, because just because a witness did not testify in a way that may or may not have led to a conviction doesn't mean they weren't intimidated to testify one way or another. That's a separate issue. You can't take the result and say, well, because the result was favorable, therefore no witnesses were intimidated.
Show me a witness that said she was intimidated because of what's on Karen Reed.
That's a different issue. We're talking the philosophy of having that charge stand out there on its own. It can. Do they have the facts in this case? No, they don't. That doesn't mean they can't try to get it.
Let them try to get it, and then you make the motion that it's still barred because no one had said that the testimony would be different. If they lied on the stand, where they lie on the stand, they didn't say anything.
We don't know. We don't know. There's no way to know that. And the result of Karen Reed's trial is irrelevant. Whether she was convicted or acquitted, whether a witness was intimidated or not, doesn't depend on the result of that trial. You can be intimidated and the person could be convicted. You could be intimidated and the person could be acquitted. So there could be standalone charges. I don't think the evidence exists, but they could be there.
I don't think it exists, and I think technically that they'd be barred because the trial is over. And what are you intimidating for? What? I mean, I just think that this is bullshit. But that's a technical legal term.
Yes.
So
well, the facts lead to that conclusion. But we're talking about, can it stand alone? Yeah. Let me see the goods, and that's what they're trying to get. Are the goods.
Why did they try to get it before the trial?
Well,
They got the gosh darn phones.
I can't answer for their incompetence. I'm sorry.
Estoppel? Okay, how about estoppel? Okay, I'm going now with estoppel.
You're going with estoppel? Unclean hands?
Unclean hands, estoppel, bullshit. Okay.
Okay.
Warrant
Latches,
under the Fourth
or latches
Amendment,
in there.
Article 14 of the search and seizure law requires law enforcement to act diligently to obtain a search warrant without
You see Dina
unreasonable
there?
delay.
And here they did by seeking a search warrant for the seizure of the phones. The question is whether there's any case says that there's an independent obligation to seek further warrants authorizing looking at other aspects of the phone besides seizing the physical phone itself in a timely way.
Well, I think timing is relevant, Judge. They could have done it. They could have done it with the special counsel Mello. He chose not to. He went into the grand jury, which they returned a no bill. And Your Honor, this court knows better than anybody the level that requires an indictment to get issued. Here, they returned a no bill, Judge. I mean, there was less than any evidence that Ms. Reed conspired with Mr. Kearney to intimidate or participate in any intimidation of any witness in this case. But I think it is relevant in terms of now they want to come back and look at her two phones And they have all that evidence from Mr. Kearney. They have, I think,
All right, no,
five or six.
I understand those arguments, but I'm still trying to find a case, if you have one,
Because
that
there
comes up
is
in the
none.
context of a warrant authorizing the initial seizure of the device, and then there's a delay in searching that device or searching that physical piece of evidence.
Just give me one moment, Judge.
Sure.
I'm going to
We
argue
have,
that
we have
this is
Tim
also a
Bradle
due
trying
process-
to give him an argument.
Yeah,
for it.
due process violation. I'm throwing the book at everybody here.
Because I think it's
You know,
crap
I
too.
don't have a case off the top of my head, Judge, but I think just going back to the reasonableness under the Fourth Amendment, I think again, I don't think would have came up if we just let it stay and didn't ask for the two phones. It was only after I asked for the two phones that now this is somehow an ongoing investigation. When they've had the investigation was done, and there was nothing to it. If they had, and I think with this evidence, Judge, that they have, they can go back to 10 grand juries. They're going to get 10 no bills. But
Okay.
I think in terms of reasonableness and timeliness, Judge, I think, it's almost 2 years.
Okay, I'll take it under advisement.
Yeah.
Well, what a shocking that
And the
is.
matter, it does have a next date of December 5th. at 2 p.m.
Oh, you know what? I'm sorry, Margaret. I didn't get to the issue of if the warrant issues for the search of the phone, do you have any contest with the protocol that was set out by the Commonwealth?
I do, Judge. I don't think the Commonwealth, in the preventive medicine case, the defense has some say in, who would be a part of the taint team. So I don't take the representation from the government that they should just set it up.
I don't have any opposition from you or any substantive response to you for with regard to the protocol that's proposed by the Commonwealth.
Because there's
That was
no
part of
ring
the
on the
frustration
phone.
that I had with the papers as they came to me.
Crossing over. I understand, Your Honor.
Yeah, so there's a elaborate protocol laid out here in the Commonwealth's papers, and I need specific details as to what you're proposing if I'm going to authorize the Commonwealth to search through the two
You
phones.
can't. All right,
I
stop.
take it you can make
Stop. Okay, here's the thing. We oppose this. We are not going to agree to a protocol. This is like doing when you do the DNA and you go in and they kind of smoosh you around. Or bring your expert in to watch the DNA testing. No, because then it happens before. I'm sorry, Judge. We think it's improper. We do not agree to any protocol. That way you preserve your right to the protocol. All right? So don't fall for that, Buzang.
Yeah, he's trying to be helpful, and he really doesn't need to be. I'm glad he raised the point, but he's protecting himself to some degree. But
Got some lawyering going on here.
this whole under advisement thing just chaps me.
Under advisement. But don't fall for that. Don't fall for that. You don't have a comma. We don't agree to the protocol. Period, Your Honor. If you're going to order the phones to be searched, that's fine. But you make your order. We don't agree to the protocol.
Yeah, then
And
you
we
get
don't
your
have any
grounds.
comment right. That's all. That's it. Here. Preserve
right.
your appeal.
backup of the phones and do the search off the backup, and you can promptly return the phones to Ms. Reed.
I assume that's the case, Your Honor. I will check.
Okay.
But before we get to that, Judge, could I just have a couple of weeks to provide some opposition to that? It'll be
Opposition to what?
to the taint team part of the government's motion.
No. You can talk to Mr. Cosgrove. The two of you folks can talk and come together, come to an agreement as to a protocol. And if there are any disputed paragraphs or sentences in that protocol, you'll show them to me in a document indicating that there's a disagreement as to this or that and the reason. Not a long brief, okay? Not an elaborate briefing, but if I'm going to allow this, there's going to be a taint team protocol put in place. And I assume you're going to agree to 95% of what the Commonwealth is proposing, and you may quibble around the edges. I've issued these before. Okay, it's not all that complicated. So I'll give you 10 days to do that if that gives you folks.
I won't give you 2 weeks. I'll give you 10 days.
10 days, right.
Yeah, I mean,
Don't agree to the protocol.
he's so
or agree to a
wishy-washy.
protocol That is so unbelievable that the Commonwealth can't agree to it. Okay, that's what you do. And
I mean,
if
it shouldn't even come to that, but he's basically telegraphing his decision.
Right.
He's basically saying, I'm going to allow this, so let's get ahead of it by you guys working out how that's all going to happen.
And then you've lost your right for anything. Once you agree to that protocol, you're doomed. Don't agree to the protocol.
Or to even meet and confer with him. I wouldn't do that either.
I wouldn't do that either. Right. I'm not meeting and confer with him. I'm not agreeing to the protocol. It's your decision, Judge. You think this protocol is going to be within the constitutional limits. We think no protocol can meet constitutional limits because we think this is wrong. Period. End of discussion.
And he's done it before, so just do it, Judge, and then we'll respond accordingly.
Right.
So just have some balls. I swear these guys are such pussies.
To confer with the idea that you'll reach agreement on most of it.
Very good, Judge.
Any problem with that? Is that enough time?
No, that's fine, Your Honor.
Okay.
Always happy to talk to Mr. Boozing.
All right.
I give up.
All right. I think there'll be very few things for me to resolve. So I'll give you 10 days. That'll be, what are we? We're already October 8. How about if you get it to me by the 21st, October 21st?
Good enough, Judge. Thank you.
And I'll take it in Word form so that I can make whatever edits I feel like I need to make to your version, taking one side's or the other's version. I'm likely to be more like a baseball referee, is take the version that I think without, fiddling too much with the language. So both sides really need to be reasonable.
Understood.
Okay, 10:21.
Okay. So, we'll await your responses. You have until October 21st. And the matter's next on
Thank you,
December
Your Honor.
5th.
Thank you, Madam Clerk.
At 2 p.m. for hearing on the motions to dismiss. Thank you. We'll see you then.
Your Honor, may I be heard on the disqualification issue?
Going.
Mr. Bradel, in what docket did you file a motion for disqualification?
Judge, I believe that was filed in all three dockets. This one is styled as an in-ray search warrant docket. It's 20, I have it right here, just 1 second.
When was the motion for disqualification filed?
I believe last week.
October 6th.
10-6. I'm not going to hear you on that until I get a response.
Sure, I understand, Your Honor. It's just a little bit cart before the horse, I think, because counsel is forging ahead under a conflict. And, I don't think counsel for the Commonwealth should be permitted to keep forging ahead on this thing until the conflict issue is resolved. So I would ask that you stay any action on the part of the Commonwealth.
I will not. I will not. I'll put you on for a hearing on a motion for disqualification. But I'm not going to do it on the fly or without everybody having adequate opportunity to be heard.
Sure. I understand.
Or
When would you
Cosgrove
like
would
to
just ask for
schedule
more
a hearing on
time.
that motion?
That's all.
Is that Margaret, do you have? We could do December 5th, but do you have the motion for disqualification? I have an affidavit.
Sorry, Judge, there's an impounded and a redacted one. Redacted is for the public docket, and there should be an unimpounded one, or unredacted one, rather. That's for the court. And I believe they were filed in all three of those dockets. So the 24 and the 23 case for Mr. Kearney and this in-ray search warrant case. And if not, I'll just make sure Madam Clerk has them in this case, but sure.
The files are so voluminous.
Okay. What's the status of the 2025 case?
The
25 CR 88.
That's the pizza case.
That's had a little bit of a back burner, Judge. I think there's a pretrial where it's in the pretrial phase right now in terms of discovery.
All right, but there's no disqualification motion filed in that one.
Correct, Your Honor.
Okay.
That's correct. The 24 case on the part of Mr. Kearney, Mr. Cosgrove acknowledged and withdrew. The 23 case we contend
I'm sorry.
Sorry.
Say that again.
Sure. The 24 case on the part of Mr. Kearney, that's 24-0043.
Yeah.
Mr. Cosgrove has acknowledged and withdrawn from that case, and I believe he's got a couple more weeks to confer with the district attorney and provide some sort of a replacement. The 23 case, we have now moved to disqualify him as for the same exact reasons why that apply in the 24 case, in the sense that Ms. Gattani is suing him and is also a key witness in the 23 case by the government's own admissions. The detective on the case swore to it.
Yeah, that's fine. So you haven't filed a motion to withdraw on the 2025 case?
Correct.
Okay, so we'll take up the 2020. We'll put all the cases on when it's an appropriate time to do a hearing.
Sure.
So when would you like to do the hearing?
Judge, could we do it a little before December 5th in November at some point? And if we can't get a date right this second, can we report?
Oh, you can get a date right this second?
Okay.
We'll figure it out.
Sure.
December looks better to me than November, Your Honor. And part of the problem I have is that in moving to disqualify me, particularly since Mr. Bradel has, or Mr. Kearney has moved as well to disqualify the Norfolk County District Attorney's Office, is who should respond to the motion to disqualify me? Should I respond? Should or can the Norfolk District Attorney's Office respond, or should it be the Attorney General
until the
or someone else?
disqualification is decided? That Bradel just asked for that, and now Cosgrove will say, "Well, how do I respond?" This is exactly what Bradel asked to happen, to have delayed, because we don't have a decision on the disqualification.
Yep. And all of this is wasted effort if, as expected, he's gone.
There are discussions underway as to who the appropriate person is to respond to that, and I expect it will take a little bit of time to hash that out.
Okay. We have a hearing date, December 5th?
We do, Your Honor.
All right. It should be here. Yeah.
Yeah, I can't
What?
wait.
No.
That's all I would.
Yes,
Wait,
it
you
should be
want
in
the-
this session, December 5th.
What about
Very
the
good.
others?
Okay. And that's at 2:00?
Yes.
Okay.
Thank you.
So, Mr. Kearney, your matter is continued to.
Okay, clerk repeats everything.
So wait a
regurgitated.
second. So he wants it to have the same time as the
Yeah,
other hearing. But he
and-
wants to
and
move the other
Cosgrove-
hearing to his
Cosgrove couldn't make it. Cosgrove couldn't make it. So he's not good for any date other than the one
December
that's
5th.
already on the schedule.
So what, are they going to be in two courts on December 5th? Or Krupp wants to move all of them to him? Let them transfer them all to him.
Well, yeah, that'll be interesting too, since it started with Doolin's had his hand in most of it. I think Lisa Davey was asking who initially issued the search warrant for the phones. This guy,
This guy.
the Kruppster. The Kruppster did. So okay, we got buried in that for a bit, but I think it's time. And we heard about a redacted document, didn't we?
That's time
So,
for
let's see if-
Massachusetts Mad
See if I can
Libs.
clean up my
Mad
mess
Libs
here
Mass.
and get to that.
Mad Libs Mass. You all ready to play? You're ready to
Make-
play Mad Libs Mass? And that has to
Make
go
sure I
with
got the right
these-
one. I got to
the,
find the right one here. Hold on.
all the
Hold
block.
on.
Well, I'm just talking about all the block redactions. Now we don't know how this is going to go. You guys can go off the
I
wall.
have no
This is
idea.
a
This could
good
go off the
story.
rails.
It is game right. And to fill in the blanks, okay? When we're going to see these blanket things. And
Okay,
this
so what-
has to do with Aidan's affidavit to disqualify Cosgrove.
This is technically Bettero's affidavit on
Better,
behalf
I
of Mr.
apologize.
Kearney.
Right. I
And
apologize.
so we know the crux of most of this shenanigans is because of the Lindsay G interaction lawsuit that got Cosgrove off the 2024 case. And now there's been a supplemental declaration filed to attempt to get Cosgrove really off the whole enchilada and disqualify Michael Morrissey and the whole DA's office, which means for the cases to continue, you've got to transfer them to another county because there's nobody left in Norfolk that can follow these. Okay, so do you want to start this first one? You want me to? What do you want to do?
No, you start.
Oh, let me
You've got
start.
control of the thing, and then let people fill it in. We have a whole like 1,000 people on here.
Okay, I'll read, and
chatting.
I may put my own in there, and people want to send along theirs, they can. On December, number 11 here, paragraph 11, on December 28, 2023, almost 2 months prior to Lieutenant Fanning's sworn claim that Miss Peter provided the 30-second clip to Tully, Miss Peter emailed Mr. Mello and DA Tully. Subject line, "I'm an idiot," referencing their joint, that was my Mad Lib there, referencing their joint conversation from the previous day. So send along your Mad Lib. Number 12, Ms. Peter and Mr. Mello and
Wait,
and
wait, wait.
Tully.
What's the Mad Lib
Well,
for the first one? What's the first one?
I
Let me
just said I'm an idiot. Subject line. I'm an
subject line.
idiot.
Wait,
That's the
wait.
subject line from Ms. Peter to Mello and Tully. I'm an
Are you
idiot.
sure about that? You're saying I'm an idiot. What do you all think? I'm an
It's
idiot.
Mad Libs. Anything goes.
Anything goes. But what else? What if people want us to stop talking? This is Mad Libs. We can't because you got to talk over us. You have to see. This
Just
is
send
the whole
in.
point. The whole point. This is subject line.
This
Michael
is a very
says
tough
I'm
one.
an idiot.
12 is tough. Look how
Yeah.
long it is. So you got to get creative. Ms. Peter sent Mr. Mello and Tully a list of her most delicate underwear that she can't get washed properly. She opined that if I didn't get them so stinky and they weren't so stained, perhaps I could get them more clean. See, that's number 12.
So wait, so let me go back to number 11. Let me just have my Mad Lib on December 8th. Almost so much Fanny's own sport claim. Ms. Tully emailed Mr. Mello and the subject line, I need to be laid.
Oh.
I could be
Referencing their
it.
joint conversation. That must have been one hell of a conversation.
Yeah, Mr. Peters said, Mr. Mello and DL Telly. Well, the last guy I had, he wasn't so great. So now I'm looking for you. She opined that anything would be better than being with special prosecutor unnamed. I'm not going to name. I'll take any one of you. Anyone have any ideas? Come on.
I have no idea. I'll let you scan those as I look at number 13. Miss Peter attached. Where was I going with this? I'm following mine and yours. Miss Peter attached a list of soiled underwear, which on information and belief included the 30-second clip Mr. Novak introduced to the grand jury. I have to go to number 2. You have something for 13, or should I move on?
Well, yeah, I have something for 13. Miss Peter attached.
Yes.
A porno snuff film.
Included in a 30-second clip. Okay.
Yeah, porno included 30-second clip of Mr. Novak and Mr. George. Porno snuff film.
All righty. Moving on. Stand by while I find the next victims.
Come on, everybody. When you're dying, you're all dying and choking on your wines, I see, but you got to fill in the blanks. I mean, we can't, nipple rings. We can't be the only two out there. I'm Catholic. I'm not even supposed to be saying these words.
Yes, what is wrong with you? Okay, so we're at number 14 now. Miss Peter, let me get that one open here for me. Miss Peter assured Mr. Mello and Tully that she would continue to do everything she possibly could to look like a lying sack of poo. Ms. Peter's December 28, 2023 email to Mr. Mello and Tully included.
I'm going to let you finish, and then I'll go back in your mind.
Oh, included batteries that she had been collecting related to the alleged wiretapping violations. On January 3rd, 2024, 10:44, Ms. Peter emailed Mr. Mello that she needed her batteries for something far more intimate and important and would not be providing additional batteries. On January 3rd, 2024, at 11:08, Ms. Peter emailed Mr. Mello, "Damn it, I need those batteries," of which she alleged was proof that Mr. Kearney illegally wiretapped Ms. Gaetani.
Okay, so let's go back to me, number 14. Okay, come on, the chat. I need help. Okay, Ms. Peter assured Mr. Mello and DL Telly that she would continue to flash her body in front of C&C Pizza until Aidan Kearney came out and responded by intimidating witnesses. Ms. Peters, December 28, 2023, the email to Mr. Mello and DL Telly included more porno photographs relating
I
to
see where you're going.
the alleged wiretapping violation. January 16th, January 3rd, 2024, at 10:44, Ms. Peter emailed Ms. Mello that she, if I do this,
yeah. Hold on. Yeah, Harvard. Yeah. Miss Linda Kenney Baden, she can't come back. Oh, I'll let her know. Okay.
I
ahead.
had an orgasm because the pizza was so good. She never got to go deal with the wiretaps of Ms. Carney.
Okay, do one more, and then I think we've gone totally off the rails. Or is that it? You done? Is that it?
No, we have number 17 on January 3rd, 2024 at 11:08. Ms. Peter emailed Mr. Mello. I came of what she alleged was proof that Mr. Carney.
Oh my God. Okay, well, thank God the FCC doesn't handle streaming. Okay, so.
All right, so wait a second. Where are you going to keep going? You guys got to keep going. We can go back and you can fill in the blank. We've done the best we can for Massachusetts Mad Libs.
Yeah, the goal is not to see them ahead of time, just like with Mad Libs. Okay, are you done?
I think
I think I'm done.
I think I'm going to hell.
I got. There's one more page. Okay, one more page.
We have to have a new show. Yeah, I'm going to take you shopping all on Amazon with me for Amazon Day, and instead I've got to go to the confessional with the priest who's probably a pedophile who sexually assaults people, but
Oh my
won't sexually
God!
assault me because I'm a female.
Only in Massachusetts. Okay, one more. Hold on.
Michael's thinking.
Yeah, well, I'm actually looking at the rest of the sentence. I wasn't before. I was just hitting the blanks. Okay, January 3rd, 2024, 11:08. Ms. Peter emailed Mr. Mello and DA Tully a slice of pizza, which she described as exactly the type of pizza she had been eating at the time she saw Mr. Aidan Kearney wiretapping her. Ms. Peter asked Mr. Mello and DA Tully if they would like her to dip that pizza to where Mr. Kearney posted the alleged wiretapping calls. She noted, "I don't dip my pizza anywhere that I don't want to dip my pizza." On January 3rd at 11:50, Mr. Mello acknowledged receipt of this evidence. Emailing Ms. Peter, understood. On January 3rd, 2024, at 1:06 p.m., Ms. Peter emailed Mr. Mello and DA Tully. The subject line was, "Leave my pizza out of this," with 2 emojis and 3 exclamation points.
Okay, on January 3rd, 2024, at 11:08, Ms. Peter emailed Mr. Mello and DA Tully, "I need a yellow sofa," which is described as the place that I can complete all these porno movies to show in front of CNC Pizza to get Aidan Kearney to confess. Ms. Peter asked Mr. Mello and DA Tully if they would like her to suck the pineapple pizza to where Mr. Kearney posted the alleged wiretap call. She noted, "I think I've got this under control with the pineapples." Okay. On January 3rd, 2024, 11:58, Mr. Mello acknowledged, pineapples are for like swingers. You know that when you see them in the background. It's a long story. On January 3rd, not my story. It's a long story having to do with the roommater who used pineapples. On January 3rd, 2024, at 11:50 a.m., Mr. Mello acknowledged receipt of the evidence, emailing this pizza. Delish. On January 3rd, 2024, at 1:06 p.m., Ms. Peter emailed Mr. Mello and DA Tully, subject line. "I think you've hit the nail on the head. I think we've got him with a dildo up his ass."
Oh my God. Okay, here we go. All right, so I have to go take a shower now. So
You wanted Mad Libs, everybody.
did anybody? I don't. Did anybody really want Mad Libs? Is that true?
They all wanted Mad Libs.
I loved Mad Libs growing up.
Yeah.
I mean, you had an actual paper that you wrote on.
They were supposed to participate here, not let me take the heat. Like tomorrow, I'm going to be really serious as a lawyer and show you what a good lawyer I am. But everyone knows they also have a very big sense of humor. Okay. Joey Kane still gifted 1 Justice Serve.
Yeah, despite that, Joey Kane, wow.
The Deer Beach caregiver gifted 1 Justice Serve TV membership. we may need a hospice nurse for some of the people in our chat, Madeira Beach caregiver, who may have just passed out because they couldn't believe that I could be capable of doing Massachusetts Mad Libs the way it was. So, yeah, you could do a poll. We could put the we can put these all in some poll, Missy, and have all of you get together in a chat room in some way. Because right now I see a lot of
I think that sounds like sex trafficking to me. Sounds like violation of the Mann Act. Okay.
Anyhow, but tomorrow night, in all seriousness, we are going to be very serious. We, our New Jersey attorneys, we're really good New Jersey attorneys. I've got some of the best coming on here. It's going to discuss Aidan Kearney and the cyber stalking complaint that's been filed. Now, we touched upon it briefly the other night, but not us. We actually had the complainant in our chat, and I did invite her on our show to give her side of the story. She said it was only one side of the story. We're probably not going to discuss the facts as we are going to discuss the law and whether or not what Aidan Kearney wrote about was intended to be in a cyber stalking law, whether the law is applicable.
Yeah, the cyber harassing statute, which we'll get into in detail, is very specific. Right. And I just don't know how anything she alleges fits that law. So we'll get into that.
We have, and by the way, we've already pulled out the legislative history. We have the letter for the Assembly, for the Senate. We have a case that's been decided under it already that we're going to discuss. And we have the law itself and a number of other things with some great people who are great New Jersey criminal defense attorneys that you won't get anywhere else but here on Justice Served TV. Why? Because I'm your New Jersey girl. And
look, you just took that down before we could acknowledge it.
I took Stephanie down?
Yeah, Steph
Okay.
Annie.
Oh,
yeah, there it is. She's
I'm
actually
sorry.
paid
I
us to
apologize.
stop doing that. That's what she paid us. Please stop. Here's some money. Just stop.
Seriously, love you guys. Hilarious. I mean, I have to tell you that I thought it'd be more like you guys would be more interactive, you know, that maybe we could have you come on and just jump on and say stuff. I didn't know that I was going to get stuck with all this. And Michael Bryant actually.
Yeah, you went off on, you went off on this porn pizza tangent that, yeah, unfortunately, it's probably not far from the truth. That's the scary thing. All
right. And we are working on next week a lot of stuff that will go on to members. So you have to subscribe, become a member if you'd like. Subscriptions cost nothing, but membership does. And we do have a surprise guest next week. And also, Michael Bryant, I'm going to say this publicly right now. We have to do a show next week on a big injustice that could be happening in Texas. That's Robbie Robertson, who could be put to death on October 16th. For allegedly a shaken baby syndrome death. Science has been disputed. It's been disputed, and he's also suffers with autism. He lives with autism, so his tone, demeanor, and all have been taken out of context. And I apparently did that on the show, for which I've apologized for somebody who Wallflower knows was posting who may not have come out as it said, and then I may not have responded as it said. And for that, I apologize. But this is even, let me take this one step further, because it's somebody who can be put to death for a crime that he did not commit. So one of those days next week before the 16th, we have to do a show.
Gotcha. Okay. Madeira Beach Caregiver, thank you. Gifting a JSTV membership. And one more thing before we go, one more shameless plug tonight. True Crime Tonight will be live. I'll be on, it's an iHeart program. It's live on the West Coast. But 10 to midnight on the East Coast, I'll be on for the hour from 11 to 12. We're going to be talking about all of these Aidan Kearney, Brian Walsh. I convinced them to get into the Kelsey Fitzsimmons case because it's so outrageous. So we're going to be talking about all those cases. So if you get a chance to tune in or catch it on the replay, iHeart Media, it's called True Crime Tonight.
And Michael Bryant is always great. And by the way, I'm getting a lot of compliments from you, from guests who say that you have the best media voice they have ever heard.
Yeah, I'm all about the superficial. That's what I'm looking for.
It's him. Thank you, thank you, everybody, for joining us.
Yes, thank you for putting up with us. We appreciate that.
Subscribe, share, like, notify. Okay, now we're told we're not supposed to do that at the end, but we're really
whatever.
Tonight, you know. And,
once you've gone into pizza porn, what's wrong with just saying like, share, subscribe?
You know?
All right. I'm Michael Bryant. That's Linda Kenney Baden. We are Justice Served TV. Please, despite what you've just heard, Try to do the right thing.